Ghanatube so your mom official pa yeda masipa say kese muni yetimi atena fi nimuni na kese mo enjanye Merry Christmas to all our lovely viewers and na nsem ayokoso any de eba ewo Ghana ha munim say ye de brem na mate na mehu Christmas season but news ni de say drop here munji ntim say Ghanatube for ye de brem na mo ahwe ma amiti akonyi wan say media stories ni erbe medin amejiso ene ye mission yanko ene ko hwe nsem ayokoso any de eba ewo manyam.
But we are opposed to this application and rely on our affidavit in opposition and the statement of case in support of that affidavit in opposition. My lords, except to add that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, not a single one of them, has deposed to an affidavit in this court. General Justice 13 just saying that Electoral Commission go and perform and complete your constitutional duty. None.
Oh, you mean the individual applicants?
Yes, my lords. There's none before you. They have not deposed to
How about the first applicant?
My lord, the first applicant is not a party who has stood for election and for which he is claiming that he has an interest. He's an official person. These are individuals. The first applicant will not go to parliament. It are individuals. They are before you. They have not said anything. My lord, well, he said he has sponsored. Let the sponsorees, if the sponsorees who go into parliament, not the sponsorer. My lord, the second point I'm making is that I'll refer the court to the case of Bobier versus 21st Century Construction Limited. Another civil appeal number J4/5/2014. It's a judgment of this court dated 9th March 2016. Suit number J4/5/2014. It's a judgment in which my lord presiding and his brother now retired Justice Badebe delivered the ruling, and their ruling touched on the effect of Order 5, Rule 1. Order, my lord, with respect, Order 4, Rule 5.1. And with your kind permission, if I may read.
CI 47.
Of CI 47, my lords. No proceedings shall be defeated by reason of misgender or non-gender of any party, and the court may in any proceedings determine the issues or questions in dispute so far as they affect the rights and interests of the person who are parties to the proceedings. My lord, even if we transpose this originating notice application into a writ, by this rule, the court has the right.
Why do I not a writ? Why do you talk?
No, that's why I use the word even if. Okay. Even if we do that, the non-joinder will not defeat the proceedings. The court has a right to go left or right, and if it does, their course of action.
And for NAT for yen yokoso any the eba or manimuna or so egusu witty and Ghanatube is one and say the same no bete say a diplomat say dipis one so with the ten of fear and the bro now who now what now wash the yokoso any the eba ever or minimum and some ebisu as well so say
is one of appeal. So far in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore the Surera should lie. Respectfully submitted. Thank you.
Oh, Counsel. Right. But you argued Hawa Yakubu in your. You argued Hawa Yakubu.
Yes, my lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No. My lord, the order had an injunction placed, but in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-joiner, but you can question it on other parties.
Yes, my lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my lord. And then also, one last thing, now that you have brought it up, my lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my lord will look at it as an application. My lord, there is an application because of the way the numbering is managed. I'm not able to. It is an application. Let me give you.
Counsel, take your time.
Oh, my lord. Well, my lord, this is the application dated 16th. It was filed on the 16th of December 2024. My learned friend made reference to it. But in that particular matter, he hasn't brought the ruling of the court. There is a ruling of the court on that particular application. So, my lord, to wrap up, none of the applicants before the court have made. Yes, thank you. I'm most grateful.
Okay. Thank you very much for saving our time.
I like the word mania.
Yes, Mr. Nimako.
My lords, we are also opposed to this application. We filed a legal position case on the 25th of December 2024. We rely on all the depositions made in the affidavit and the exhibits attached, and the authorities listed in the statement of case. My lords, this application on the document of the court, which all parties to the action were not served with a said application at the time when you were dealing with the mandamus application. My lord, we submit. The application for joinder was indeed a non-starter. That is because, my lords, there are specific rules dealing with mandamus application. And my lords, in Boyfio, this is 8 years for properties. Boyfio, this is 8 years for properties. 1996, 97. IGLR 531 at 533. This court held that the law was clear that where an enactment had prescribed a special procedure by which it was that procedure alone that was to be followed. Malos, Order 55, Rule 5.2 has provided for the procedure by which notice of an
for any for years, I cost any the eba or manimuna or so egusu out with the Ghanatube swan and say, the same no better say, Eduadzi one so we did tell of here, and the bird grown now who now what's here now wash the air cost so any the eba ever or minimum, and some ebisu as was so say.
Apply for judicial review can be communicated by the court to any affected party. That procedure is not joint application. The court may order that notice, and it is may order that notice of the application shall be served on any person not named as being directly affected by the application, if in its opinion, an opinion of the line, desirable that a person should be given notice. It is a rule, my lord. It is a rule, not by joint application. And my lord, this is a discretion which a court has to exercise. It's a discretion. It's a discretion. And if a court exercises discretion, whether rightfully or wrongfully, the aggrieved party, if so minded, cannot come by judicial review. The nation should arrive.
What is your authority for that?
My lords, if I may refer this honorable court to page 3 of my single case. Page 3. Republic versus Court of Appeal, Espati Chachushikata, 2005-2006.
Oh, read the report.
Read the report. Very well.
If you have the report there.
Yes, yes. The clear thinking of this court is that.
What page are you quoting?
Well, page 619. 619.
Yes, yes.
The clear thinking of this court is that House Supervisory Jurisdiction and Article 132 of the Constitution should be exercised only, in the word underlined, only in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to the jurisdiction or are so plain as to make the application a complete nullity. My lord, if I may even
I get the point, but you see, you would agree that the Espati Chachuchikata case and the ground that was being discussed by Georgina Wood, JSC as she then was the ground of error of law. Let's pay attention to the fact that they also have a ground of failure to observe the audio alterum pattern. So, yes, if it comes, your point holds. But also address the area of the failure to observe the audio alterum pattern.
Yes.
You have argued it, but I think you should expatiate on it.
My lord, we stop it. That a non-party to a suit cannot complain. Cannot complain. That his right to fair hearing has been breached. In this case, my Lord, I saw the Republic versus High Court, Accra. High Court, Accra. Ex parte, Danso, and others. (2015, 2016), one LGLR at page 760. 760. One Supreme Court of Ghana law report at page 760. Holding one. Holding one. This court held in dismissing application for judicial review as follows. That in spite of the first ground by the applicant alleging breach of the right to fair hearing being a fundamental right that is available to parties to an action, this court is unable to extend its scope to persons who have not, on the record, yet become parties strictly so as to speak. My lords,
but there are several decisions. Republic versus Colleague Magistrate, ex parte Amponsa, which has been cited by Amenuvo. They said that as for sexual rights, their public law reliefs, you don't have to be a party. And then we have
my lord, it's about capacity. It is an order.
No, I just want to say that the general blanket statement may not be true because there are alternative authorities. If in this case you want to make a distinction, fine, but judicial review is a public law relief, a non-party can come for it. Ex parte Adavali and so many other cases.
Yes,
but make your point.
Yes, what else? So the point we are making is very simple. The High Court only made an order directed at the public body to perform public function. To simply go and collate and declare a winner of a public elections.
For her and now, just a run kind of miss fair, and one some air cosso, any the epa, and what a year than a ham semester pass, a Christmas is in show who see if you say, a lovely viewers in Yamu, by the master, someone yatena all year round. Ha, a Ghanatube, so Michelle, and now from the Sadia, minimum eating cry.